they ought to be treated with respect, and their presumption of innocence must be protected. In my view, this is an extremely serious matter when individuals and state agencies violate with impunity a non-derogable right. I quote from the Bible that even a Roman citizen 2,000 years ago could not be subjected to a cruel and humiliating punishment. I set out the story of St. Paul when he was about to be flogged and put in chains, but when they realized that he was a Roman citizen, the magistrate and the army commanders panicked because a Roman citizen could not be put in chains. If a Roman citizen could not be flogged 2,000 years ago, how can a Ugandan citizen, a member of parliament at that, be beaten publicly by police officers and subjected to cruel and inhuman treatment? This must stop. The police must uphold the dignity of citizens. It is upholding the dignity of citizens that makes them proud and promotes patriotism. The police in Uganda has no right to flog match members of parliament, beat them and humiliate them the way they now routinely do, which this court takes judicial notice of as being a notorious fact. This is completely unacceptable and it must stop forthwith. The Attorney General must ensure that this is brought to an immediate end. Today, members of parliament are flogged. Tomorrow, it shall be a minister. And then, God forbid, the Chief Justice. We would have gone full circle. If that action of the police and army in forcefully evicting members of parliament from chambers and arresting them after manhandling them, I find that the action of the police and the army in forcefully evicting members of parliament from chambers and arresting them and manhandling them violated the Constitution. In my considered view, the Speaker of Parliament should have simply adjourned the House to the next day. Then the Sergeant at Arms would have denied entry to the members who had been suspended. Members of Parliament who were injured and manhandled or otherwise mistreated are at liberty to seek redress in an appropriate court of law. Having said that, the question is whether the intervention of police and army in Parliament had the effect of vitiating the entire process. I have gone through this and reproduced where the Deputy Speaker said the House was so full, and he was saying that today was special, some people have just come in for the first time. Then Robert Chagurani, the MP, said today we know that studies have been made and surveys have been carried out. Madam Speaker, I have had the rare opportunity to traverse the whole country, and everywhere I have been, from north to south, from east to west, the people are saying do not amend the Constitution, and find that there was no evidence to suggest that members of Parliament, in spite of what happened, were prevented from consulting because everyone said they consulted. I've also found that the House was full. 417 members of Parliament were present. 315 voted for the bill, 62 against, and 2 abstained. The House was so full that members were standing in the lobby and the Speaker could not close the door. So for that reason, I do not accept the argument that whatever happened vitiated the process, because all members of Parliament turned out and voted the way they did. It is on record that Parliament did provide each member of Parliament with 29 billion for the purpose of consultation. A few members of Parliament on their own volition returned the money. I must mention that they were 14 in number according to the evidence of Jane Chibirige. This list did not include Mrs. Betty Nambozi Bachirike. She was not truthful when she stated in her testimony in court that she returned the money. All she did was to write a check, which was never cashed. She knew very well at the time she came to court to testify that the money never left her account. She did not appear to be a truthful witness. I can safely conclude that since members of Parliament were given money, they accepted it, they were free to consult the people. All in all, no sufficient evidence was provided to prove that members of Parliament were prevented from consulting the people. Before I leave this issue, I'm constrained to comment on the 29 million. I must state that it was disturbing to find that whereas all members of parliament were given this money, almost all of them did not use it for the purpose of facilitating public participation. Those who attempted to do so simply held a few meetings, talked to a few they had selected. This is not because they were prevented by the police from consulting. They simply did not bother to consult. I have stated above that this consultation fell short of the required constitutional standard. It is disturbing to note that the money was given to members of parliament irrespective of the location of their constituencies. A member of parliament for Kampala Central, where parliament building is located, was given the same amount as a member of parliament for Chisoro, Arua, or Kotido, 100 miles away. Similarly, members of parliament who have no voting rights, being ex-official members, were also given this money, although clearly they have no constituencies to consult. It appears to me clearly that the money was paid to members of parliament as a gratification. That money must be accounted for by the parliament's accounting officer in respect of members of parliament with constituencies. In respect of members of parliament without constituencies, they must refund this money, or it should be recovered from them through a process established by law. Having stated that, I must reiterate what my brothers have stated, that the police had no powers to issue directives stopping members of parliament and specifically members of the opposition in parliament from consulting the people of Uganda. The police officer who issued that directive ought to be brought to account by relevant authorities. This is a free and democratic society. It is not a police state. The Public Order and Management Act must be implemented subject to the Constitution. The act of the police issuing a letter violated Articles 1, 2, 23, and 29 of the Constitution. Whether the consultation were marred by restrictions, I find that they were not, but I say that the police directive was issued in complete and total disregard of the Constitution. The police appears to have acted and continues to act as if this country has no constitution. They assume quite wrongly that a police officer, being a police officer puts one above the law. The police has no power to curtail liberty of Ugandans except as provided for under the Constitution. The police message does not mention under what law it was issued and how it was to be implemented. It criminalizes intent. It goes against every letter and spirit of this Constitution. It takes us back to the dark days of the past, which I have attempted to set out earlier in this judgment. By directing the police to stop intimidating persons perceived to be supporting the removal of the age limit, without issuing a similar directive in favor of those who were supporting the age limit removal,